Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. We reported last year on the Court of Appeal decision in MWB v Rock Advertising. The Court of Appeal decision had caused worry and uncertainty when it found that a contract had been varied by an informal oral agreement, despite the contract specifically stating that oral variations were not permitted. This concerning decision meant that formal contracts could be accidentally varied by informal business chat. Fortunately, the Supreme Court has now reversed that decision. The Competition and Markets Authority of the CMA may intervene in any merger if the turnover of the target exceeds 70 million, that's the turnover test, or if the combined market share is or exceeds 25%, the share supply test. Under amendments to the Enterprise Act from the 11th of June, certain mergers will be subject to different thresholds. The turnover test shall be reduced to 1 million and the share supply test shall only relate to the target share rather than the combined share. The businesses caught by the new test includes any businesses supplying goods subject to export controls and businesses producing computer processing units and/or associated software. If a party materially breaches a contract, the other party, the innocent party, will usually be entitled to terminate and be compensated for loss of a contractual bargain, usually a loss of profits claim for the remaining term of the contract. If, however, the defaulting party has a right to exit the contract anyway, e.g. a right to terminate without fault, commonly known as a termination for convenience right, or has any other right to exit the contract, then the courts have to decide whether the innocent party's claim is limited because of that right. Now, there have been slightly inconsistent decisions on this point, with one 2014 case saying there must first be a factual inquiry to determine when the defaulting party would have exercised its right to terminate for convenience. A recent court decision, however, found that where the defaulting party has a right to not proceed with the contract, that will limit the innocent party's claim. A company, Skip It Containers, and its two directors have been prosecuted following an incident where an employee was injured when his arm was caught in a conveyor belt. The company was fined £120,000 and the directors were given 16-week custodial sentences, suspended for 9 months, as well as significant personal fines. These prosecutions again highlight the HSE's more robust approach to prosecuting poor health and safety practices. On the 10th of May, the Network and Information Systems Regulations of 2018 came into force in the UK. This imposes new rules on operators of essential services, that's OESs, and digital service providers, DSPs. OESs may include companies that operate in energy, transport, health and digital infrastructure, e.g. domain name providers. DSPs are those who provide an online marketplace, online search engines or cloud computing services in the UK. OESs and DSPs must manage their security risks appropriately and notify relevant authorities of incidents that may have a significant impact on the continuity of an essential service within 72 hours. This is not limited to personal data incidents like the GDPR. There is a sliding scale for non-compliance, with the highest being 17 million. Now, there is still considerable uncertainty about these regulations and it's hoped that more guidance will be issued soon. An understandable assumption for companies with less than 250 employees has been that Article 30 of the GDPR exempted them from maintaining records of processing. Unfortunately, that exemption now seems to have been quashed. The exemption only applies if data processing is occasional, and the Commission's view is that where an organisation employs staff, it will inevitably regularly process personal data. The ICO has updated its guidance on the right to data portability, and this is now available on its website. The right to data portability allows individuals to oblige an organisation to port their data, in some cases, to an alternate organisation. The Court of Appeal decision in Abraham and others v Nottingham City Council has sent a stark warning to employers that assume that an employment contract variation has been agreed. In this case, the council implemented a 2-year pay freeze from April 2011. The unions did not agree to the freeze, but no grievances were raised. In 2013, the council decided to extend the pay freeze. A formal collective action against the council followed. The Court of Appeal decided that all employees had a contractual right to incremental increases, and withholding the annual increments from April 2011 was a breach of contract. The Home Office and Disclosure and Barring Service have updated their guidance for employers on requesting DBS checks for potential employees. The updated guidance includes some useful information on how employers who might rely on a previously issued DBS check can spot a counterfeit document. It also gives guidance on the DBS's online application form for basic checks, which was introduced back in January. The guidance is available on the government website. In a recent case, an NHS trust sent a letter making an employee redundant, but there was a dispute about when the notice was given. Was it when it was delivered or when it was read by the employee? The date was critically important as it had a big impact on the employee's pension entitlement. The Supreme Court, agreeing with the Court of Appeal decision, stated that for contractual matters, not statutory notice, and where the employment contract does not express when the notice is deemed to be given, it will be the date when the employee reads the notice. We reported last month on the case of Ali v Capita that determined that Mr. Ali was not entitled to enhanced 14 weeks paternity pay that his female colleagues were entitled to for maternity leave. Another Employment Appeal Tribunal case on the same point, Hextall v Chief Constable of Leicestershire Police, has now left the door open to a different decision. The EAT found errors in the way that the Employment Tribunal had dismissed Mr. Hextall's claim, and the case has been sent back to be heard by a different Employment Tribunal. We'll have to now wait and see how this case develops. Implementing one of the Taylor Review suggested reforms, the Employment Rights Act of 1996 has been amended, and with effect from the 6th of April 2019, every worker, rather than only employees, will have the right to an itemised pay statement. CEO of Barclays, Mr. James Staley, has been fined £642,430 for his failing in connection with a whistleblower report. On receipt of a second letter, Mr. Staley had asked his security team to identify the whistleblower. Now, this action was stopped as Mr. Staley and the security team were informed that the letter was being treated as a protected whistleblower report. Subsequently, Mr. Staley was provided with an update from compliance that the allegations were unsubstantiated and that the investigation was about to be concluded. Mr. Staley then, without checking with compliance, instructed the security team to try and identify the author of the letters, which included seeking video evidence. Thank you for tuning in for this month's Commercial Bulletin. For more information on any of these stories, please contact me at Radius Law or my colleagues at LexisNexis. We'll be back in July with more of the month's key legal updates.